trying to synergize your energies. You will have a one management. You will have more efficient way of production. Maybe, for example, when Tata is acquiring Chorus, then the Tata may have a good market in Europe. Or, for example, when Vodafone is acquiring Hutchinson, it may have a more better synergy. So that's the entire rationale, to minimize their cost. So that's a positive aspect. Negative aspect would be, which is to be taken care by the competition authorities. What could be the negative consequence? If they have a more than 50% share in the market, and your next competitor, that's a number 3 in the market, he is just having a 10%. So there is every possibility that after the merger, this entity is going to monopolize the market. They may either limit the output production, or they may increase the price, or they may also form cartel with small players dictating their terms. That look, we are in the 60% of the market, we want to have a Coke instead of 10 rupees, we will sell it at 20 rupees. And the consumer is not having very good alternative choice, because those who want to drink, they will drink either Coke or Pepsi or Mirinda or Fanta. All these are owned by only these two companies. So there is no alternate choice. So the main job of the competition authorities would be to look into what is the benefit and what is the loss. If the benefit is more than loss, I'm speaking in very, very general terms, it's a huge complicated procedure, and in order to have this kind of investigation, the competition authorities, for example, if I have seen the working of the European Commission, they have a full-fledged DG competition, and they have more than 300 lawyers and 300 economists, and they are just looking into, say, Microsoft or say all these big companies which is trying to have any kind of acquisition. For example, Microsoft is acquiring any small companies in Germany, which is a German-based company just. So what will be the effect of that merger in that relevant market? Relevant market, I mean within that country, Germany. What could be the implication of that merger in entire European Union? So if the relevant market is just Germany, they have to notify to the German authorities in Berlin. But if it is a community dimension means which is having an effect of more than 2 European countries, then they have to notify to the European Commission in Brussels. And all these procedures will be followed. So that's one thing to do. Next would be, after this identification of potential adverse effect on the market, next step would be, which the competition authority generally look into, what is the level of entry. We normally call it entry barriers. There may be situation that there may be just 4 players in the market, not because of the reason that other people are not willing to come, but because of the reason that it's a huge investment to enter into that market. For example, if you look at the glass market, so you require a lot of investment in order to start that business. Glass market or cement, all this business, or tire industry. So you are having a very concentrated market wherein you have 3-4 major players, and they are doing all these kind of activities. So they will look into those aspects, and finally the ultimate test which the competition authority is looking into is the generation of efficiencies. It may be possible that there may be 5 competitors, and out of 5 competitors, after the merger, there will be only 3 competitors in the market. But if the competition authority is coming to the conclusion that after this 3, we will have a reduced prices. If it is the interest of the consumer, if it is in interest of the economy, you are generating more efficiencies, okay, let's go ahead with that. So that's a kind of 5-step process which is there in United States as well as in the EU. In India, we are basically adopting the hybrid model of these two. As far as court supervision is concerned, we are more towards US position, whereas US courts is having a jurisdiction or supervision over all these activities which is being done by the FTC, which is equivalent to, say, Competition Commission. And when it comes to the more review process, it's more in tune with the European Commission, where you can go in appeal before the Court of First Instance, In Europe, in India, we can go to the Competition Appellate Tribunal, which is headed by a former Supreme Court judge, Justice Pasai, and two more expert members, one from, say, from economics, one from law. So there are the appellate body. They can hear the appeal both on facts as well as on law. And the final appeal goes to the Supreme Court of India. So far, we don't have any cases in the Supreme Court which actually dealing with the competition point of view. When this act was passed in 2002, we have a constitutional validity of this act itself was challenged before the Supreme Court. And recently we have a case wherein what happened, CCI, Competition Commission of India, started an investigation, and the Competition Appellate Tribunal said, no, you can't do that investigation unless you have some these materials. So basically the Competition Commission itself went before the Supreme Court, alleging that the appellate authority is not having that much jurisdiction to supervise or rule. So it was basically the tussle between the Competition Commission and Appellate Tribunal. And the finally Supreme Court in September said, no, Competition Commission of India, being an expert body, 5-7 expert member body, they can actually look into all these complaints. So they actually decided in favor of the Competition Commission. So that's the state of affairs. So far, we don't have merger provisions in place, but my own assessment is within a year it should be, because the draft is there very much on the website and it's asking for the comment. And when we will have the necessary manpower in the commission, we are going to start with this merger regulation.
Does the Competition Commission of India have
Right.
the power to deal with the hostile acquisitions, which consist mainly in acquisition of as many shares as possible from the open market? First question, Mike.
Right.
Second question is, does the Competition Commission have the power to deal with the cartelization, which is a sort of monopolization of raising the prices, like recently the private airlines
Right.
formed a cartel
Right.
and raised the price more than double the air tariff.
Right.
So does the Competition Commission have the power to curb this tendency, first of hostile acquisitions and secondly of this cartelization?
Regarding your question number first, if it is a hostile takeover, Competition Commission is very much can inquire, but the problem is in a hostile takeover, right, you have a one company A, one B. If these two companies are meeting the threshold which has been provided under the Competition Act, for example, the net asset of the acquiring company is more than 500 crore, or the total turnover is more than 3,000 crore, only then it's a mandatory on their part of these two companies to notify to the commission that there is a proposed merger. If they don't notify, the commission will investigate, and the commission can go up to the extent of demerging these merged entities. They are also having this kind of sweeping powers.
So means Competition Commission is fully equipped with the
Yes,
power to
yes,
deal with such type
yes.
of hostile
As far
acquisitions.
as your second query is concerned regarding cartel,
Cartel.
Section 3 strictly prohibit cartel kind of activities. And I'm just wondering why in this all these aviation thing, nobody so far has approached the Competition Commission, because the Competition Commission are at the moment are examining more than 129 cases, and most of the cases is regarding cartels.
Can the
Right.
Competition Commission take an action, suo moto action?
Yes, even suo moto they can investigate, or they can also act on the complaint which has been filed by any consumer organization or you as a aggrieved party. So it's possible. It's a very much possible. And
Is there any provision in the Competition Act?
yes, it is there. The substantive provision is Section 3, and whatever the procedure, it's also there in Section 29, 30 onwards. All these procedure has been prescribed under the Act. And the best thing is, if you have just noticed, few days ago there was a cartel. I don't know the exact title of the case, but the issue was the Competition Commission was investigating a cartel, and it asked for certain details from the competitor, all those companies. And companies actually provided, just in order to have an eyewash, they provided incomplete information. And the Competition Commission of India, which is unprecedented in the history in India, has imposed a fine of 1 crore rupees to the wrongdoer company. So the Competition Commission can go up to the extent of imposing fine of 1 crore rupees for just not providing the information. And if it is found that there is a cartel, the commission come to the conclusion, yes, there was a cartel, it can impose a fine up to 10% of their global turnover, which is to be calculated on the basis of their 3 years average. So if they have a turnover of say 3,000 crore rupees, You can imagine the 10%.
That means the Competition Commission is much more equipped to deal with this kind of cases than its earlier avatar.
MRTP. Indeed. In MRTP there was no teeth, but in the Competition Commission we have a lot of these enforcement mechanisms. Just one small...
MRTP did not have such effective measures.
Exactly. Just one comment. You can imagine the situation in Europe. We have a glass cartel, Saint-Gobain, Asahi and all these players. And in 2008 December, European Commission imposed a fine of more than 1 billion euro, which is coming around 6,000 crore rupees. Though the party has challenged it before the European Court of Justice, that's a separate issue. But this kind of fine has been imposed by the anti-competition authorities worldwide. So.
Thank you very much. Just one question.
After.
Okay. It is very, so that we will complete it as soon as possible and then it will be finished for all. So now I request MC Chopra to please make his presentation and take a limited time.
Sure. Good evening.
Discuss it
Sure. Good evening, everyone. It's an honor to be here in this elite gathering, and I'll try to be as precise as possible. I do understand that this topic, mergers and acquisitions, has been taken majorly understood by people in regards to overseas mergers and acquisitions. But I'm here with a very different approach today. I'm not going to discuss mergers and acquisitions in detail the way the elite members of the chair have done so far. Mr. Avinash has given us some really nice introduction about how mergers and acquisitions and what are the laws behind it. I would rather like to look into the topic through the point of view of corporate development, because the topic here today is overseas mergers and acquisitions for corporate development. People simply ignore corporate development being a very essential part of it. And therefore, there are some very important hidden issues within the topic itself which are easily ignored, and they have been ignored. A very important fact to look into is that there are thousands and thousands of mergers and acquisitions taking place every year globally, and in India it's a boom at the moment. However, there are very few which come into light, because they are the most important. The others never actually reach that point. They are not that successful. The reasons behind that failure are never discussed. The reasons behind the failure of corporate development in itself are never taken care of. I'm here to actually look into the areas of corporate development through that different angle. I've therefore divided my topic into three major aspects in regards to mergers and acquisitions, and I'm going to discuss corporate development briefly, how we should approach corporate development in regards to mergers and acquisitions, and at the end I would like to just give an essence of overseas mergers and acquisitions and why India or any developing economy should look into it as a very important factor to be understood in the economy itself. I'm not too sure, but it's a very funny incident. Just yesterday, I asked someone that I'm going to present on this topic, and they said, why are you talking about corporate development, mergers and acquisitions? There's a lot to talk about in itself. And I was taken aback because I thought corporate development is something not understood by people. If you look into the dictionary and people talk about corporate development, it is simply explained that corporate development is actually a variety of planning options and strategies that can actually help to move a company towards its goal. That's like a layman's language to understand the concept. And corporate development is the way in which you can actually find the tune and you can actually create the existing structure to come into, practice, to come into a successful merger or acquisition. I don't actually find the need to define mergers and acquisitions as what they are, but I'll just touch over. But before I do that, there's a varied approach when we look into corporate development. First, we can understand that it's used and it's broadly accessed in regards to reshaping the management teams of corporations, be it service sector, be it transportation, pharmaceuticals, or whichever. We normally use it to reshape the management arm. We also understand it with the development options. When we actually look into a merger or acquisition, we need to understand what we are getting into. We need to understand who are the people we are dealing with, who are the associations, what are the resources we have to actually talk about. And if we take care of all these factors, you can actually look forward to a very great merger or acquisition, whichever way it goes. We normally, when we look at mergers and acquisitions, we are either talking about two profitable companies coming together, they're merging to make a bigger market, they actually come into more into monopoly. I would not go into the competition